Nazar Mohamed and Azruddin Mohamed, and the Minister of Home Affairs, Attorney General, and Magistrates. In this case, the second applicant, Azruddin Mohamed, is the leader of the Opposition of Guyana, and the first applicant, Nazar Mohamed, is his father. On 20th October 2025, the United States government submitted a request to the government of Guyana seeking the extradition of the Mohameds to face an 11-count criminal indictment, including allegations of conspiracy, mail and wire fraud, and money laundering. Following receipt of the request from the USA, on 30th October 2025, the Minister of Home Affairs of Guyana issued an authority to proceed under the Fugitive Offenders Act, requiring the magistrate to proceed with the case and determine if there is enough evidence to justify an extradition. The following day, on 31st October 2025, the principal magistrate issued arrest warrants for the Mohameds, formally commencing the proceedings in the Court of Committal, which remain ongoing. In December 2025, while facing proceedings before the magistrate, the Mohameds initiated judicial review proceedings in the High Court against the Minister of Home Affairs, the Attorney General, and the magistrates. In those proceedings, the Mohameds challenged the validity of the authority to proceed issued by the minister and sought a stay of the proceedings before the magistrate. Their primary contention is that the minister's decision to issue the authority to proceed was tainted with bias. Earlier this year, their claim was dismissed by the High Court on 4th February and by the Court of Appeal on 17th March. The applicants now seek special leave to appeal to the Caribbean Court of Justice, or CCJ. While the High Court and the Court of Appeal refused to stay the proceedings before the magistrates, at a case management conference held in March of this year, the CCJ did stay those proceedings pending the delivery of its decision. The CCJ also ordered that the hearing of the special leave application be treated as the hearing of the substantive appeal. That hearing took place on 21st April, and the court reserved its judgment.
Good afternoon, President. Thank you so very much. Caribbean Court of Justice, Appellate Jurisdiction, an appeal from the Court of Appeal of the Cooperative Republic of Guyana, judgment delivery in CCJ application GYACV number 1 of 2026 between Nazar Mohamed, Azruddin Mohamed, the Minister of Home Affairs, Unej Waldron, the Attorney General, and Magistrate Judy Latchman. The members of the delivery panel this afternoon are Mr. Justice Anderson, President, and the presiding judge.
Good afternoon, Council.
Madam Justice Rajnath Lee.
Good afternoon, everyone.
Mr. Justice Barrow.
Good afternoon.
Madam Justice Ononewu.
Good afternoon, everyone.
And Mr. Justice Balkan.
Good afternoon, everyone.
Council, may we have the appearances, please?
Deputy Registrar, I am also in this matter. Peter Jamada.
I missed you, Judge.
That's all right.
Yes, Counsel. Mr. Justice Jamada. Sorry about that, Judge. I think I just mixed up yourself and the other judge who may not be here. Thank you so much, Counsel. May we please have the appearances? Thank you.
A very good afternoon to Your Honors. Appearing on behalf of the appellants Nazar Mohamed and Azruddin Mohamed today are myself, Sian Durjan, in association with Ms. Sasha Bridgemohan Singh, Mr. Damien De Silva, Mr. Adam Hussein, and we are led in this appeal by Mr. Fayad Hussein, Senior Counsel, and Mr. Roysdale Ford, Senior Counsel.
Thank you, sir. And for the first respondent,
Good afternoon, Your Honors. Should it please the Honorable Court, Mr. Douglas Mendez leads me, Clay Hackett, on behalf of the first named respondent.
thank you, sir. And for the second respondent,
Good afternoon, Your Honors. May it please this Honorable Court. My name is Shoshana Lal. I appear with Mr. Nigel Hawk, our Solicitor General, Dishon Prasad, Joshua Kulan, and we are led by the Honorable Attorney General Mohabir Anil Nandalal, Senior Counsel, for the second named respondent, please, Your Honors.
thank you. And for the third respondent,
Good afternoon, Your Honors. Aruldranath Gosai. I respectfully appear for the third named respondent.
thank you, counsel. The court has arrived at a decision in this matter. There were 3 judgments comprising that decision. The lead judgment was authored by Justice Barrow and me. There was a separate judgment by Justices Rajnorthley, Jamadar, and Balkan, and a third judgment, separate judgment, by Justices Anoniwu and Ebo Osuji. I regret that for reasons which could not be avoided, Justice Ebo Osuji is not now on this call and is not likely to be on the call before the judgment is delivered. As the co-author of the lead judgment, I will now call on my elder brother, Justice Barrow, to deliver the judgment of the court. Justice Barrow?
Thank you, President. General elections were held in the Cooperative Republic of Guyana on 1st September 2025. The second applicant, Mr. Azruddin Mohamed, was elected as the leader of the opposition and was sworn into that office in January 2026. The first applicant, Mr. Nazar Mohamed, is his father. On 28 October 2025, the government of Guyana received a request from the government of the United States of America for the extradition of both applicants to that country. The request resulted in the Minister of Home Affairs issuing on 30 October 2025 an authority to proceed, or ATP, pursuant to Section 12 of the Fugitive Offenders Act, which gave effect to extradition treaty arrangements between Guyana and the United States of America. The ATP signified to the magistrate that the request for extradition had been received and required the magistrate to proceed with extradition proceedings in accordance with provisions of the Act. While those proceedings were ongoing, the applicants brought an action for judicial review in the High Court on 23 December 2025, seeking, among other things, an order that the ATP was null and void because of bias, both actual and apparent. The applicants also sought a stay of the extradition proceedings. The alleged bias was said to have arisen from the minister's affiliation with the governing political party, the People's Progressive Party Civic, in circumstances where the most senior representatives of that party, including the president, vice president, and the attorney general, had publicly described the applicants as criminals and in other derogatory terms during the electoral campaign. It was also alleged that the ATP was fatally defective because prior to issuing it, the minister had consulted with the Attorney General, who was allegedly biased. On 4th February 2026, Chief Justice Singh, sitting in the High Court, dismissed the application and refused the stay of the extradition proceedings. The Chief Justice held that in issuing the ATP, the minister was exercising an executive rather than a judicial function, and therefore the rule against bias did not apply to its fullest extent. The Chief Justice also found that the allegations of bias had not been established, since it had not been alleged that the minister herself made any of the adverse statements against the applicants, and the expression by her colleagues of disdain for the applicants could not be attributed to her so as to taint her decision with bias. Costs were awarded to each of the 3 respondents to be paid on or before 27 February 2026. On appeal, the Court of Appeal similarly dismissed the appeal and refused the request for a stay of the extradition proceedings. Like the High Court, the Court of Appeal held that the minister was exercising an administrative function in issuing the ATP, and therefore the issue of bias did not arise. All that was required was for the minister to address her mind to and comply with the statutory requirements regarding the issuance of the ATP. Notwithstanding the Court of Appeal's determination that the rule against bias did not apply to the challenge decision, that court considered the submission on bias. The court found there was no direct proprietary, pecuniary, or equivalently close personal interest that would warrant automatic disqualification for bias. Additionally, the Court of Appeal found that the fair-minded observer would not conclude that there was apparent bias on the part of the minister, would appreciate that the ATP was merely a preliminary step in the extradition process, and that the applicants would have the benefit of all the safeguards against bias provided under the Act. The Court of Appeal also rejected the argument that the minister and/or the Attorney General should have delegated their statutory functions and powers to issue the ATP either pursuant to the Carltona principle or Section 27 of the Interpretation and General Clauses Act. Dissatisfied with the decision of the Court of Appeal, the applicant sought special leave to appeal to the Caribbean Court of Justice. On 25 March 2026, this court granted an interim stay of the extradition proceedings and ordered that the hearing of the application for special leave be treated as a hearing of the substantive appeal. The hearing focused on 2 central issues, namely, 1, whether the minister and/or the Attorney General was tainted with bias, actual or apparent, such as to tarnish the issuance of the ATP, and if so, 2, whether the law required the minister and/or the Attorney General to delegate their statutory powers and functions in respect of the issuance of the ATP in the circumstances. In a joint decision delivered by President Anderson and Justice Barrow, their honors held that the applicants had met the threshold of arguability needed for the grant of special leave. That is, it was arguable that the court below was wrong to decide that the rule against bias did not apply to the issuance of the ATP. In adjudicating the appeal, the honors found that the rule against bias does apply to the ministerial grant of the ATP, but that the question of whether there had been a violation of that rule had to be determined by the context in which that question arose. In the instant case, the judges found that the ATP process does not import the full panoply of procedural rights available in judicial proceedings. There was no general right to be heard prior to the issuance of the ATP. There was no requirement for the minister issuing the ATP to be free from political bias. What was required was for the minister to engage in a process that allowed for consideration of the factors contemplated by the Act. Their honors found that the applicants had not challenged the process that led to the issuance of the ATP, save for the allegation that the minister was politically biased. There was no allegation that the minister omitted to consider a relevant factor or that she considered an irrelevant one. While the Attorney General, as chief legal advisor to the government, must necessarily be circumspect in any comment on extradition requests upon which his advice may be sought, the decision to issue the ATP was statutorily vested in and was, as a matter of fact, exercised by the minister with very minimal advice from the Attorney General. In these circumstances, determination of whether the Attorney General was biased served no probative value. The honors expressed the considered view that it should become the practice in our courts, except where it is manifestly clear that the extradition proceedings must fail, as for example, where the ATP was issued by the wrong person, that while challenges to the issuance of the ATP may be brought at any time, such challenges should only be heard after the completion of the committal proceedings. This practice will be consistent with the international framework for extradition, encourage prompt performance of extradition treaty obligations, and provide a reasonable balance between the interests of the person whose extradition is requested and that of the state. This practice would also be in line with the normal judicial process envisaged by Parliament in, for example, sections 17 and 21 of the Act. In the opinion of President Anderson and Justice Barrow, the challenge on grounds of bias having failed, it was not necessary to consider the other ground of appeal concerning whether the minister and the Attorney General ought to have delegated their statutory powers in the circumstances. However, their honors expressed grave doubts that there could properly be delegation of the powers under the Act to issue the ATP to any person who was not a minister. Additionally, in light of their findings that the issuance of the ATP was not tainted with bias, their honors similarly found it unnecessary to address the arguments on waiver and the doctrine of necessity raised by the minister on her cross appeal. Justices Rajnath Lee, Jamadar, and Balkan delivered a separate opinion on several key aspects of this matter. They were satisfied that the test for special leave was met by the applicants to the standard of arguability. On jurisdiction and prematurity, they held that there is no legal basis that prevents the applicants from commencing these judicial review proceedings to quash the decision of the minister to issue the ATP where bias is alleged in the decision maker and or decision-making process. Prematurity does not arise in the circumstances of this case. There is pragmatic good sense to the issue being raised at the earliest stage possible. On the issue of waiver, they were of the view that it cannot be said that the applicants were plainly aware of all the relevant facts, or that by their conduct they clearly and unequivocally waived their right to object on the ground of bias. Furthermore, the applicants did not delay and, at the earliest opportunity, questioned its lawfulness on the ground of bias. On the salient issue of bias, they underscored that the rights guaranteed under the Constitution of Guyana permeate the entire extradition process, requiring a heightened standard of scrutiny where implicated. They held that the rule against bias can apply to the issuance of an ATP under Section 12 of the FOA, and the fair-minded and informed observer apparent bias test is the appropriate one. On the facts, they concluded that there is no appearance of bias established against the minister as the decision maker or by reason of the larger ecosystem in which the minister operated. However, in relation to the Attorney General, they concluded that there was a real possibility that the Attorney General was biased. Despite this, they were of the view that the Attorney General's apparent bias had not so contaminated the process as to raise a real possibility that the decision of the minister to issue the ATP was vitiated by bias. On delegation, they determined that the doctrine of necessity does not arise in the circumstances of this case, and delegation in relation to both the Attorney General and the Minister is arguably permissible under the General Clauses and Interpretation Act of Guyana. On costs, they ordered that each party must bear their own costs in this appeal. Their reasons highlighted that these proceedings are situated at the intersection of public law and criminal law, raising issues of considerable public interest. Further, this action is not frivolous or vexatious or plainly hopeless or an abuse of the court process, and has led to important clarifications on the applicable law. In conclusion, they highlighted the importance of judicial independence for all courts in Guyana and opined that the public statements by the Vice President and the Attorney General referencing the existing judicial proceedings can undermine the independence of the judiciary and have deleterious effects on the administration of justice and the rule of law in Guyana. They are to be denounced. In a separate opinion of Justices Onano and Ibo Osuji, delivered by Justice Ebo Osuji, they opined that the dismissal of the appeal is borne out by difficulties attending both the substantive content of the complaint of bias, as well as by procedural policy considerations concerning the rightness of the litigation. They grant that fairness must attend decisions in public office, and fairness abjures bias. But the law eschews the blinkered view in the appraisal of bias. That appraisal is not done exclusively from the complainant's point of view, registering only his grievances and disregarding everything else. Bias is assessed from the point of view of the fair-minded, reasonable observer, fully informed of all the material facts and circumstances. It means that the complainant's grievance of bias must be appraised through the spectrum of all the facts and circumstances in the given case, while a fair-minded and informed observer should be a man or woman of the world, she or he is also not to be led astray by conspiracy theories in the absence of credible evidence. In this case, the approach outlined above thus requires account to be taken of both the hostile comments that senior government officials made against the second appellant and all the considerations that bear on the minister's issuance of the ATP. Foremost in that regard is the question whether the minister who issued the ATP had a real discretion to decline issuing it. If not, the complaint against the minister accused of bias becomes largely academic because no minister will have free rein to decline issuing the ATP. In that regard, some of the main considerations would include the incidence of external factors that pressed against the minister presented with the extradition request received in a case like this. These include not only the sovereign acts of the requesting state, evidenced by the accompanying indictments and arrest warrants that culminated in the extradition request that was made, but also the incidence of international obligations arising through extradition treaties or treaties on transnational crimes implicated in the notion of extradition. Then again, the fact that the fair-minded and informed observer accepts that the case of bias is fully made out in relation to the issuance of an ATP does not mean that procedural policy considerations would accept an attack against the ATP as ripe for litigation in every case outside the judicial proceedings that are an integral part of the extradition process. This is because the extradition process, beginning with the committal proceedings, is amply equipped with precisely the facility of judicial review to remedy any injustice occasioned by a biased issuance of an ATP. There is no need, as a general proposition, for a separate track of judicial review for the ATP alone. At the inception of the committal proceedings, it is enough for the requested person to request an early preliminary, to register an early preliminary objection against the ATP. Thereafter, any appeal or judicial review of the ruling on the preliminary objection attacking the ATP should await the completion of the committal proceedings. It is at the proper time when the challenge to the ATP is ripe for litigation that the fair-minded and informed observer's assessment of bias will be fully brought to bear. At the appropriate time for the inquiry into bias, the fair-minded and informed observer must consider all the facts and circumstances of the case, including, as in this case, whether the conducts complained against as indicia of bias were gratuitous on the part of those impugned, or whether the impugned conduct was provoked by the complainant, thus depriving him of clean hands in the overall circumstances of the case. On the facts and circumstances of the present case, the second appellant does not have clean hands. He provoked verbal attacks against him by his own earlier attacks against government officials or his own willing participation in a general brawl of political calumny. Having regard to the opinions expressed, this court decides: 1, the application for special leave to appeal from the decision of the Court of Appeal is granted. 2, the substantive appeal is dismissed. 3, the interim stay of the extradition proceedings imposed by this court on 25th March 2026 is hereby lifted. 4, there shall be no order as to costs before this court. Thank you, President.
Thank you, Judge. Permit me to make just 1 or 2 short comments. The first is that in the circumstances where counsel did not receive advance copies of the judgment, I'm proposing that there be a post-delivery opportunity for counsel to review the judgment and to provide whatever comments that are customary on a review of the judgment before it is posted, so that the judgment will be delivered immediately after we rise to counsel. Counsel is asked to review and to come back to us with any comments they may have within 24 hours. We will then consider those comments, perfect the judgment for uploading to the website of the court by 4 p.m. on Friday. The judgment having been delivered, there is no embargo on disclosure of the content of the judgment, which will be delivered to counsel. Again, there is no embargo on disclosure, but bear in mind, of course, that we want to perfect the judgment consistent with our appreciation of any comments that you may make on the judgment you will receive very shortly. The second comment I would like to make is that of expressing the gratitude of my colleagues and myself, the council, for their very considerable assistance to us in this matter. This is, of course, a complicated matter, and we are very grateful for both the written and oral assistance provided by counsel. Is there anything from counsel at this point? Counsel for the
President,
applicants'
before you call upon counsel, I think we may have omitted to say that the costs are reserved in relation to the courts below. And I think you were to give some directions on that. We have made the order read says that there will be no other costs before us. But as I understand our agreement, the question of the cost below is reserved as part of the court's order, and we are to receive submissions on that as you will suggest.
Thank you, my brother. So I think we could leave that to the process of the receipt of the judgment by counsel and the comments that you may wish to make on that. My brother is correct in that there is an order reserving costs in the courts below. And that order is to be supplemented by directions, most likely through CMC. But we will come to that in due course. Please look out for that order foreshadowed by my brother. I would then want to ask counsel if there's any comment that they wish to make. Counsel for the applicants, appellants.
Might I just clarify one issue, Millard? Is it that the issue of the courts below, is that a matter on which we have to satisfy the 24-hour rule in respect of commentary, or is it going to be a longer period? Because we are at the end of, and we are in a bit of a, we're hard pressed in terms of time to be able to deal with that within 24 hours, as the case may be.
Not at all.
Or
That
is
is
that
not
something that's going to be dealt with?
counsel. That is not at all contained in the 24-hour rule. The 24-hour rule is relative to the usual comments that counsel may have, whether by way of clerical errors, typographical errors, names not being spelled correctly, etc. The issue raised by my brother is a substantive issue, and that will require subsequent hearings. I suspect the initial hearing will be a case management conference at which further directions will be given.
Much obliged, Millard.
You're welcome, sir. Comments from the attorneys for the first respondent?
No comments from us, please. Thank you very much, Your Honor.
Thank you. Comments from the attorneys for the second respondent?
Your Honors, we want to thank the court profusely for a very elaborate and comprehensive judgment. We look forward to reading the judgment, and no doubt it will contribute to our growing jurisprudence, especially on the area of extradition, bias, public law, etc. So once again, Your Honors, thank you very much.
You're welcome, sir. Attorneys for the third respondent?
No comments, please, Your Honor.
Thank you, sir. That being the case, I would invite, unless any of my colleagues wish to comment at this stage. If not, I would invite the Deputy Registrar to bring these proceedings to a close.
Thank you very much, President Anderson. Thank you very much, Madam Justice Rajnath-Lee. Thank you very much, Mr. Justice Barrow. Thank you very much, Mr. Justice Jamada. Thank you very much, Madam Justice Nunu. And thank you, Mr. Justice Balkan. Thank you, Counsel, and a thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good afternoon to all. Thank you.
Good afternoon, ma'am. Thank you.